based in Singapore. I'm personally very excited about this first joint YSISC ASA below 40 event. So thank you for joining us. We have an exciting lineup of speakers. They all have a very international profile, but have experience practicing in Switzerland, respectively, Singapore and the UK, and we will briefly introduce them in a minute. Before we do that, I would just like to say a few words about the content and structure of this webinar. We are going to discuss tools to make international arbitration more efficient, and we have divided the session in two broad topics. The first topic will address tools which aim at promoting settlements or streamlining the procedure. And the second topic will discuss the pros and cons of different procedural approaches, styles, and what is most efficient. So the idea throughout the webinar is to take a comparative approach, discuss what and how it is done, for instance, in Switzerland, and how it is done differently in Singapore and the UK, and see how we can get inspiration from different practices, bridge the gap, and maybe get to an overall more efficient process. I won't say more at this stage. I will just pass the floor to my co-moderator, Catrice Gaillet. Thank you.
Thank you, Julie. Yeah, my name is Catrice Gaillet. I'm a counsel with Harriet Smith Freehills in Düsseldorf, and I'm also very happy to welcome you today on behalf of ASA Below 40, and also on behalf of my two co-chairs, Catherine Kunz and Flavio Peter. We are very, very happy to have the possibility to organize this joint event here today, and yeah, with YSISC. I have a few housekeeping matters. First of all, we want this webinar, of course, to be as vivid as possible. So please, if you have any questions, just drop them in the question box. We will collect them, and at the end of the seminar, those of the two sessions, we and our speakers, of course, will address these questions. And very importantly, after the Q&A session, we will have a remote networking event. So please do not leave at the end of the second session, because you will be allocated to different breakout rooms. And it is a great chance actually to network with members of the arbitral community worldwide. This is the chance that we have, let's say, because of COVID. So I hope many of you will join us in the breakout rooms. But without further ado, I have the pleasure to introduce the three speakers of my first session, which I will moderate. First of all, we have Nadia Al-Kanarati. She is a senior associate with Wilmer Hale in the London office. And she practices, of course, international arbitration. She is qualified in New York, but is also a Swiss lawyer, and therefore will represent the Swiss perspective. In addition, she is also a regional representative of the DAS40, the German arbitration institution, and co-teaches arbitration at a French university. Second, we have James Scherf. He practiced for almost a decade in the International Arbitration Group of Freshfields Brookhouse Daringen in Paris. He is now transferring to become a barrister at the London Bar. And there he will not only practice international arbitration, but also international English commercial litigation. And he as well teaches international dispute resolution at a French university at the Université Paris 5 René Descartes. And last but not least, we have Sia Lee. She is a senior associate with Peter and Kim in the Singapore office. And before joining Peter and Kim, she worked for leading international arbitration law firm Korea. And this is very interesting for today for our panel, she was the head of Northeast Asia at the SIIC. So let's start with the first tool right away, the so-called dismissal of manifestly unmeritorious claims or defenses. This tool has been introduced in various, but not all, of the rules of the major institutions worldwide, and we will start with Sia, who will shortly address the perspective of the SIAC and the perspective in Singapore. Sia, the floor is all yours.
Thank you, Catrice. Thanks, everyone. So I'll give a brief introduction of Rule 29 of the SIC Rules 2016, which is the early dismissal. This SIC became the first major international arbitration center to introduce a provision for early dismissal. And this was also followed by similar provisions in the SIC investment arbitration rules in 2017. If you can, maybe it would be useful for you to search the relevant rules. So it's Rule 29 of the SIC Rules 2016. If you see 29.1, an application for early dismissal can be made if a claim or a defense is manifestly without any legal merit, or the same is manifestly outside the jurisdiction of the tribunal. The use of language here is similar to Exit Rule 41.5, and this is to allow parties and tribunal to take into consideration existing exit jurisprudence. So here the term manifestly without any legal merit, it suggests that a tribunal should only order early dismissal where there is a legal impediment to a claim or defense and not a factual one. So for example, a legal impediment might be a claim which is time barred. This manifestly without legal merit is likely also have been derived from Rule 41.6 of the exit arbitration rules, which says if the tribunal decides that the dispute is not within the jurisdiction of the center, all claims that are manifestly without legal merit, it shall render an award to that effect. The express reference to legal merit was to avoid inappropriate discussions on the facts of the case at the summary award stage. The exit tribunals, as well as the SIAC tribunals, have affirmed that they may not dismiss a claim on the basis that it manifestly lacks factual merit. But this bears in mind that the distinction between legal merit and factual merit is not clear-cut all the time. So, for example, even a limitation defense has a fact as its basis, which is the time since the cause of action arose. SIC Rule 29 acknowledges this and requires the application to include the facts and legal basis supporting the ED application. So manifestly can be something that is evident, clear, or obvious, or in other words, easily understood or recognized by the mind. That was part of an award by in an exit case. And there are some suggestions that the SIC should amend Rule 29 and introduce more detailed criteria for determining the threshold of manifestness. But as far as I understand, there won't be any changes to this rule in the upcoming new set of SIC rules. Also, different than the Exit Rule 41.5, SIAC Rule 29 permits the early dismissal of both claims and defenses. It is not sure whether the tribunals will limit its application to affirmative defenses or whether they'll apply it to potentially all issues raised by the respondent in its defense. And also, unlike exit, SIAC Rule 29 does not impose any time limit on its ED application for claims or defenses. So an application can be filed in theory after the exchange of written submissions or even after document production.
Okay. Sorry.
Yeah.
Sia, thank you very much for this first introduction. I mean, it all seems to be quite clear, and but how often has SIC seen that this tool has already been used by arbitrators?
Right. So since its introduction in 2016, so from 2016 to 2018, there were 22 applications, and out of which 4 were granted the application. In 2019, there were 8 applications, 5 were allowed to proceed, and 1 was granted. And last year, 2020, which was a record year for SIC with over 1,000 cases in 1 year. It had 5 early dismissal applications, 2 of which were allowed to proceed. And those 2 applications that were allowed to proceed last year both got rejected. So I think these numbers shows that it doesn't seem to be having had a spike since the introduction of early dismissal in its rules. And also after the pandemic, the numbers didn't rise. So I think the parties and tribunals still seem to remain quite cautious, particularly where enforcement of the resulting award is in a jurisdiction where the courts are unfamiliar with such a concept, which is in many of the civil law jurisdictions.
Sia, thank you very much. I mean, it seems to be that it is a very good tool, and I could imagine that it can really enhance efficiency. And apparently, the SIC has chosen to introduce it into their rules. But I wonder, and I would now refer to Nadia, how it is in Switzerland. Has it been introduced in any rules, and if not, why? And how is this, for example, if a claim is possibly time barred, how is that dealt with from a Swiss perspective?
Sure. Yeah, I mean, as I'm sure most of you know, the Swiss Chambers and now in cooperation with ASA, the new Swiss Center for Arbitration, has just released new rules. And they didn't actually include a provision on early dismissal of manifestly unmeritorious claims. I tried to get the scoop for you guys on why that is, whether there were discussions on that, but as anyone who knows the Swiss knows, we're very good with confidentiality and secrecy. So I've been told by members of the review committee that they cannot actually discuss whether or not they have discussions on this point. So I can't tell you why that is not part of the new rules. I know with the new rules, they wanted to sort of just do a light touch revision. So that might have been one reason, just a very practical thing of they didn't want to introduce too many new things. But as Seya has already sort of hinted at, I think that that might be the early dismissal sort of tool as such might be more of a common law thing. I think it's quite common in civil litigation in, for example, the US and the UK as well, but not so much in civil law litigation. I think we're not quite as familiar with the tool. And I think there are some risks as well with early dismissal, right? It as the name would suggest, it comes quite early in a proceeding when claims aren't really fleshed out yet. The terms always sound quite clear, right? Manifestly without merit. I mean, yes, everybody agrees. Claims that have manifestly no merit should not proceed in an arbitration. But I think as we all also know and suspect, we will vehemently disagree on which claims have manifestly no merit. Otherwise, we wouldn't be in an arbitration. So I think there's a lot of risk and maybe also hesitancy on the part of arbitrators to so early in a proceeding determine that there's no chance for a claim to go forward. And so, as Seya has mentioned, there's a risk, obviously, of a challenge on the basis of your right to be heard having been violated. But I think also tactically, it can be quite difficult, right? Let's say, as Seya has mentioned, the defense of a statute of limitations, right? I think that's often the topic that's brought up. But an arbitral tribunal might be quite hesitant to really admit that challenge so early on, when they don't have all the facts, when one party claims that actually, in fact, the statute hasn't even started running, or it's been told along the way, and there's lots of things that you have to sort of evaluate. Whereas at the end of a proceeding, a tribunal might be quite happy to say, oh, we don't want to actually deal with these claims. That statute of limitations defense sounds quite promising. Let's go with that. They might be happier to do that at the end of a proceeding rather than at an early dismissal stage. And so you might also sort of strategically not want to waste your promising legal defense on an arbitrator that's quite hesitant to bring that up so early. So in short, hasn't been introduced in Switzerland in the new rules, doesn't exist really in that sense in civil litigation as well. But there's certainly ways to deal with that, right? We know bifurcation could be an option if it's often used for jurisdictional questions or liability questions, but there's no reason why it couldn't be used for other aspects, right? So if you really wanted to sort of get some stuff out of the way early, that would be a way to do it.
Thank you very much, Nadia. I'm conscious of timing. James, could you just shortly say what's going on from an English perspective, and then we would move directly to the second tool, which I think is much more contested.
Sure, thank you very much. And I'll just add the footnote that there has been an innovation in this area recently in the English landscape, and that the LCIA rules were amended in 2020 to include an express provision for seeking early determination. It's at Article 22.1.8. And basically, you can knock out a claim if it's, quoting now, inadmissible or manifestly without merit. So it's quite similar to the Singaporean test that Sia was discussing. There is no data at the moment on how this would be administered because it's so new. There haven't been any there were no applications in 2020. We'll have to wait and see for the LCIA's 2021 casework report to see if this provision is invoked. And it's probable, I think, particularly if you have quite an English panel, that the test applied will be akin to that which is applied in English commercial litigation and under the CPR, where you can get a statement of case struck out if it discloses no reasonable grounds for bringing or defending the claim. And obviously, as Nadia pointed out on limitation might seem, for example, to be the kind of prime case where this sort of application might be brought, but the devil is always in the detail, and inevitably there'll be some factual argument or legal nuance which the tribunal which will sort of scare the tribunal into kicking the issue into the merits and not just tossing the whole case out on the as an early determination.
Thank you, James. Let's, for the record, say, well, we will see how in the next years this tool will really develop, and as you said, whether the devil really has as a consequence that this tool might not be used as much as we hope. But maybe there's another tool that we can use, and this is the so-called early or preliminary evaluation of the merits of a claim or of defenses. Usually that's non-binding, but I would ask Nadia maybe to shed a little bit light what it really means, because for a lot of common law arbitrators and common law counsel, that might be not a tool that you are so familiar with. So Nadia, please.
Sure. Yeah. So I think that this particular tool is quite a sort of a Swiss or Germanic tool. It's used frequently in state court litigation, and basically, as Catrice has already sort of pointed out, it's an early assessment by the arbitrators that's non-binding, and what they assess is basically the respective strength of the party's position. They might also even say, the burden of proof for this allegation lies with party A. We would want to see evidence on these things. We have not yet seen that. This position is weak because, and they give you sort of a rundown of where you as a party stand. Now, obviously, there's sort of a tension of when do you do that, right? So most often you would see it after sort of the first exchange of written submissions. You can do it later. There's no real rule when you should do it. There are people who do it after the hearing. I find that personally, at that point, you've gone so far down the line, your positions have hardened, it's maybe a little bit too late. But there's obviously this tension between, if it's too early, you lose the value of it because the arbitrator hasn't maybe fully understood your position. And if it's too late, the sort of efficiency gain of it is complicated. What's interesting, though, what I actually wasn't on my radar so much before I prepared for this panel, is that it's actually envisaged by the IBA rules on taking of evidence. It's Article 2.3a, and it's also in the CEDR rules for facilitation of settlement, which are based in it's an English institution. So it might be a very Germanic thing, but it seems to have sort of weaseled its way into more the international practice, which personally I think is a good thing, but we might have disagreeing opinions on this panel.
Thank you very much for this introduction, Nadia. I mean, if I take the in-house perspective now, I would say, hey, after the first round of submissions, I get a, let's say, even non-binding assessment by the arbitrator. Maybe that is a stepping stone to initiate settlement talks with the other party. That might save time and costs. So why not do it? Everyone is always complaining about time and costs. So James, what would be your take on that? It actually, if I was an in-house counsel, I would say, yes, please go for it.
I can see the attraction for sure for some clients who might want to get an early steer on where they stand and be in a better position to reach a favorable settlement. As Nadia pointed out, it is kind of anathema for common lawyers to have this kind of procedure. It sounds more like what we would call mediation, which is basically where you have both parties in different rooms, they're trying to do a deal, and a clever lawyer kind of shuttles between them and puts to each side the weak and strong points of the other and tries to sort of force them into a settlement. And it sort of goes slightly against the grain of the core of the adversarial system, which lies at the heart of the adversarial philosophy, which lies at the heart of the common law, which is that the judge or the arbitrator is ultimately there to just make a decision on the merits. And I think one of the major objections to it would be, and I think Nadia foreshadowed this, is that it does rather force the decision maker to make a substantive decision quite early on when she or he hasn't necessarily digested all the evidence, or indeed all the evidence might not necessarily be even on the table. I would add that this kind of procedure does exist in another guise, in that it's very common in both common and civil law. Well, I speak mainly for common law jurisdictions because I know better, but in a lot of common law arbitrations, you can have preliminary determinations of one or other issue, which might actually end up being dispositive of the entire case. And indeed, usually if you're seeking a preliminary issue, a preliminary determination, that is your strongest argument, that it'll save so much time and energy if we just decide this one point now, it will knock out this part of the case, or indeed maybe the whole thing. So that's not quite the same thing conceptually as the arbitrator getting everyone in the room in an early stage and saying, look, here's where I'm leaning. But it might actually practically end up in the same place. And that kind of procedure has existed for a very long time and is used frequently in common law systems. So I think common lawyers have a bit of a kind of a nervous gut reaction to this procedure, but actually something quite like it already exists. And it will be interesting. I mean, there's no doubt that under the Arbitration Act 1996, which is the governing UK legislation, that arbitrators have a general power to adopt measures like this. So it will be interesting to see.
Just as a short follow-up question, I mean, I can see your points of concern, but let's assume during a CMC at the very beginning, the arbitrators would raise this issue, whether or not they are allowed or are being granted the power to give this preliminary non-binding assessment, for instance, after the first round of submissions. And both parties agreed to that. Maybe even because the parties themselves, the in-house counsel, say, hey, let's do that. Would you think that, I mean, yes, it's party autonomy anyway, but that arbitrators also in the common law jurisdiction would be more inclined to do that?
I think they'd be more inclined to do it if they knew both parties agreed to it. I think there's an interesting question about if they were inclined to do it, even if the parties didn't agree to it, whether that would render their award susceptible to challenge. My own view, I mean, this hasn't been really tested. My own view is that it wouldn't. I mean, the Arbitration Act gives very, very wide powers to set the procedure, provided the arbitrators act impartially, of course, and that would be the hook, I suppose, in that you'd say, oh, well, they were obviously biased because they came out, quite early in the procedure and told us that we were wrong and the other side was right. Ergo, they must have been biased. But subject to that, there is a wide power to set the procedure, and also it's rather difficult to challenge awards in the English courts, absent some rather clear breach of jurisdiction or serious procedural irregularities. So I mean, I completely agree. It's always better if both sides kind of sign on the dotted line, even though one or other may end up regretting that decision once the preliminary determination is given.
Absolutely. I'm getting a hint here from Julie that we have to close up quite soon. So I'm quickly jumping to our last tool, which is, let's say it's related to the second one that we have discussed so far, whether or not the arbitrator can really act as settlement facilitator. James, very, very shortly, what do you think about this? Can an arbitrator really submit a proposal saying, hey, it has been claimed 40 million, I've set out my non-binding assessment of the claim, you have to pay 20 million, that would be my proposal. What do you think about that in an arbitration?
Very short answer, if the parties agree, fine. I think there's all kinds of informal indications that
Not yet.
Yeah. Sorry, yeah.
No, that's a great answer. I mean, if they don't agree, I think they would be quite reluctant to do that. That would be the intake. Nadia, from your perspective, what do you think about that?
I mean, I agree with James in the sense that you definitely shouldn't do it if you don't have the parties' agreement. I think as James has hinted at before, it sort of departs a little bit from the general role that we see for arbitrators, right? There's sort of a view of, okay, an arbitrator is supposed to just render a decision and not sort of get into the horse trading of, okay, but would you accept 30 million instead of 50 million? But I think especially with sort of the pressure that arbitration is increasingly facing from sort of these other alternative dispute resolution mechanisms, it's not a bad idea to sort of say, okay, well, we can offer that as well. But if it doesn't work, you're already in a process to actually get a binding decision. So it's sort of, you get both in one proceeding instead of having to go get mediation and then it doesn't work and you have to start over again. And then there's obviously a question of what does that mean? What does the arbitrator actually do? And I think there's different iterations of that. They can do nothing. They can suggest that they should settle and then step back and let the parties figure it out. They can do what we talked about before, the early assessment, which often is sort of a push to settlement. They can really negotiate with the parties and say, okay, but they say 50 million and you're at 30, so can't we meet somewhere? What do you think? How can we make this sort of a commercially reasonable thing? And then they could go as far as doing actual mediation and caucus with parties ex parte, which I probably think is quite risky from a due process standpoint. I probably wouldn't recommend that, but I see no problem with them having sort of an active role in the settlement discussion.
Thank you very much, Nadia. We have to close. Sia, I don't want to bring you from your last sentence, just with one sentence. What is your single perspective on that?
Well, of course, if the parties agree, then it's okay for the judge to be a settlement facilitator. And actually in the civil law courts, many of the civil law courts, as I understand, they do sit as mediator in the middle of the court proceedings, and they do often set a ratio or a range of the settlement amounts, and the parties do feel pressurized that they should kind of settle because the judge will be going back to the courts if they don't settle, and the respondent might end up with bigger amounts in the end. So I don't want to put too much emphasis on the differences between civil jurisdiction and common jurisdiction, but this is the same. I think similarly, I was glad that Nadia put it as a Swiss or Germanic thing when she talked about the preliminary assessment proceedings, because I haven't really come across that many of those proceedings as well. Maybe because I deal with more civil law jurisdiction arbitrators as well as civil law parties.
Thank you very much, Sia. And with that, I think we could discuss that for hours, but I will give now immediately the floor to Julie before she cuts off my head.
Thank you, Catrice. Yes, we need to move to the second part of this webinar, and we're going to discuss now different procedural approaches, different procedural tools, and see what's most efficient. The first speaker for this session is Wendy Lin. Wendy is a partner with One Partnership LLP in Singapore. She has broad experience and a very active practice both before the Singapore courts and in arbitration. And she is importantly presently serving her second term as co-chair of the YSISC committee. Next, we have Raoul Donde. Raoul is counsel at Levy Kaufman Kohler in Geneva. He has acted as arbitrator, counsel, and secretary of tribunals in over 30 international arbitration proceedings. He's worked in Switzerland and India for several years and has expertise in high-value, complex commercial disputes in both common law and civil law system. Last but not least, we have James, who will cover the English perspective also for this topic. So to kick off the second part, I'd like to start with a key conceptual difference, which is the submission style, whether we present front-loading or a pleading style, and this can have an important impact, in particular on the timing of submission of evidence. So Raoul, could you please maybe briefly explain the differences between the two styles, and what is most frequently used in Switzerland is something provided in the Swiss rules?
Thank you very much, Julie, for that for the introduction, and thank you to YSIC and ASA Below 40 for the invitation. I apologize if my voice doesn't come through as well as I would like it to. I have a sore throat for the past several days. I think it's very important, as you mentioned already, Julie, in your introduction to this question, to understand what exactly is meant by the memorial style, as we call it, or the pleading style, or what is really understood as front-loading. And once you understand that, then you can really understand how the rest of the arbitration is going to take place. So simply put, front-loading means that in your first submission, you present your entire case. You present all of your witnesses, all of your evidence, all of your legal authorities, all of your documents. Everything is presented at the first opportunity itself. And so for the claimant, that would be the statement of claim, arguably, or it could be even earlier along with the request for arbitration. And for the respondent, it will be with the answer to the request for arbitration or the statement of defense. And that is really the full case presented right at the opening. Now, in the Swiss rules, we have, in the new Swiss rules, we have Articles 20 and 21 that effectively call for front-loading. And while I think that front-loading is something which is commonly accepted in international arbitration, or at least in most European jurisdictions, it should be kept in mind that it is not something which is very common in the Asian context, which follow a more a pleading style approach. But I leave that to Wendy to explain further.
So yes, Wendy, since you call upon by Raoul, so how's the situation in Singapore, and is there any specific provision in the SISC rules in this respect?
Yes. Before I answer that question, thank you, Catrice, Flavio, and Catherine for inviting YSIC to be part of this webinar. It's very interesting. The SISC rules in Rule 20 does provide for the filing of statement of claim and statement of defenses. It was at the start of, in the early years of arbitration, I think most practitioners understood that to be a pleading style approach, because statement of claim and statement of defense is exactly what we would term our pleadings in court proceedings. But if you actually look at the SISC rules, it does require parties to set out not just the facts, which would be the case if you did pleadings, but also legal grounds or arguments supporting the claim. So what I've seen in Singapore arbitration practice is an involvement over the years as more practitioners are now handling international arbitration and getting used to the memorial style. I'm seeing when people file their statements of claim and statements of defense, it's becoming memorial light or pleading heavy. So it's becoming a mix of typical court pleadings and what you would see in memorials. It has to be memorial light in a sense, because this is filed before parties actually file and exchange witness statements. So it will not be as lengthy, but you would expect now more commonly to see people actually going into legal authorities in the statement of claim and the statement of defense, where previously, maybe 10, 15 years ago, it wouldn't have been as common.
But you would leave, if I understand correctly, the witness statements.
Yes.
For a second.
That's right. That's right. That's how the SISC rules are supposed to operate, subject to parties agreeing otherwise, of course.
Obviously. And James, how's the situation in the UK? Or
so, I mean, if we take the LCIA rules as kind of the proxy, it's actually, I mean, they seem to favor a sort of a hybrid approach like Wendy was discussing. So I think Article 15 of the LCIA rules talks about relevant facts and legal submissions together with relief and all documents relied upon. And I think the debate that I've seen before tribunals is whether all documents relied upon means all underlying evidence, so like contemporaneous documents, or actually witness statements themselves. If it's the latter, you're in a full-blown memorial approach. If it's the former, you're kind of in memorial light. I've seen tribunals assume, without actually hearing any argument on the question, that the LCIA rules calls for a sort of high court pleading style where you exchange pleadings and then you move in sequence and then you kind of simultaneously exchange witness evidence, simultaneously exchange expert evidence, which is a sort of really pure pleading approach. But that, of course, inevitably English, it's very English tribunals, sort of 3 QCs who have practices before the courts mostly, who will favor such an approach. So, in London seated arbitrations, frankly, you see a range of approaches, and a lot of it just depends upon the background and experience of the arbitrators and of the counsel appearing before the tribunal.
Okay, so now just concretely, what do you see as the advantages of a full front-loading, approach to the case versus the pleading style?
So I think the main advantage of front loading is, as Raul mentioned at the outset, you get the whole case out at the outset, meaning the respondent knows exactly what case it has to meet. If there is a possibility of some kind of early settlement or resolution, it's more likely to happen when everyone puts their cards on the table early. It also reduces the risk of ships passing in the night. So, for example, if you have a pleading system, a pure pleading system, and you get to the point where you might have to exchange expert evidence, unless you've had some kind of discussion with the tribunal about this beforehand, you could have a situation where one side doesn't know if the other is actually tendering expert evidence at all. This doesn't happen in a memorial system where you know exactly what you're meeting. I think the main advantage of pleadings, however, is and I'm talking sort of quite pure pleadings here, is you get to the truth of the matter possibly. So to give an example, if someone pleads, if the claimant pleads that a meeting took place on X date and X subject was discussed, and then the respondent pleads, oh, well, there was a meeting, but that subject wasn't discussed, right? If you were to have a memorial system, the claimant would have to put forward all its evidence, its witness evidence as to what happened at the meeting, meaning the respondent would arguably be in a privileged position because it would be able to tailor its evidence in reply. Whereas if you have a pleading system, you've got the pleaded fact of the meeting, the dispute about what was discussed, but there'd be a simultaneous exchange of witness evidence, which would mean that neither side would get to see what the other's precise case was on that issue until their witnesses went to print with their witness statements. So I think that it is an advantage that is afforded by the use of pleadings.
But still, if we look at it from really an efficiency perspective, Raul, Wendy, what do you think is more efficient?
Well, I think it really depends on the type of case that you're handling. If you know that the client might be looking at settlement, then the front-loading approach comes with front-loading of costs as well. So it may be sensible if parties are actually very keen to settle at some point and they're actively in discussions, that you take the pleading style approach, because it means that you are deferring costs to later on if parties cannot actually settle. The other point to think about, I think, in terms of whether to adopt a pleading style or witness statement style, it depends on the nature of the case. If, as James says, one of the biggest advantages of the front-loading approach is people put all their cards on the table, all the evidence is in, and so it's harder to tailor evidence subsequently. If the dispute is a relatively straightforward one, it's a contractual dispute, there isn't going to be that much tailoring of evidence. I tend to find the pleading style a lot more efficient because usually the issues are trashed out and you know what is disputed and what is not disputed before witness statements are prepared. I'm sure many of you have actually seen cases where, because the claimant files the claimant submits a very lengthy witness statement because the claimant doesn't quite know what is disputed and what is not. And by the time you actually come to the hearing itself, you realize that maybe the first like 30 pages are no longer contested, or maybe people only start focusing on the second or the third witness statement because those are the really relevant ones. So that's to me things to think about, which style to approach. And I have a preference for pleading style when it's cases that are not so complicated and there's not going to be a lot of dispute on the facts.
Thank you, Wendy. And Rahul, do you think a specific, style fit a certain type of disputes? And is this something that is discussed in your experience at the outset with the tribunal and set out in PO1 or in the terms of reference?
Yes, I mean, I agree. I think that it's important that you adopt different strategies for different cases, right? So I agree with Wendy that there are certain types of cases where a particular type of pleading, a pleading style may be more appropriate than a memorial style. I am more comfortable with a pleading style myself because I have a common law trained lawyer. But having said that, I should say that I much prefer the memorial style. I think the memorial style is a much more efficient mechanism for resolving a dispute through the arbitral process. Particularly, it may not be the best approach for when you're in a court process, but through the arbitral process, I think it does make a difference. And I think there's a factor that we also need to keep in mind here is the arbitral tribunal's involvement. If you follow the pleading style approach, then you're kind of building up a case bit by bit, and you can expect the arbitral tribunal will kind of weigh in at the end after the case is built. If you move to a memorial style, your kind of case is built right at the beginning, more or less, right? And the arbitral tribunal, you can expect more involvement, more engagement from them because they know the entire case right from the beginning. So I think that it really does, it depends on the case. It does also depend, and as you said, on Julia, or as you hinted at, on the arbitral tribunal itself. It's a discussion which is done commonly at PO1, at the procedural order number 1 stage itself. And I think by then the parties have a fair idea. They know who the tribunal is. They know what their own case is, what their own resources are. I think cost is a very, very valid point that Wendy mentioned, and I couldn't agree more. Memorial style obviously incurs more costs at the beginning of the arbitration, especially for the claimant. So I think by that stage, you're well placed to know which approach you would like to follow. And potentially the tribunal is also a slightly better placed to give some sort of directions as to how it thinks or what it thinks the best approach should be.
Thank you, Rahul. Now moving to the second topic, because time is running fast. I'd like to discuss procedural tools to ensure efficiency in arbitration proceedings. We all know that the lack of efficiency is one of the recurring criticisms towards arbitration as a dispute resolution process, and users express a desire for a more efficient and faster proceeding. So there are different tools available and also innovations in terms of procedural efficiency. So I'd like a bit to explore what those tools are. And Rahul, can you please just, which one is the most common and most efficient tools in your view?
Well, I'm not going to be the most bombastic speaker. I'm going to say the most mundane thing possible. I think the most efficient tool is to have a good procedural calendar, set right at the beginning of the arbitration, and identify to the parties as early as possible. If there are potential requests for bifurcation, if there are potential requests, other anticipated requests for interim measures or what have you, as much as can be anticipated and as much as can be prescribed in the procedural calendar at the beginning of the arbitration, the better. Of course, that calendar is not set in stone, and it can and should be modified. But if you have a good calendar set in consultation with the parties at the beginning of the arbitration, then subject to any kind of broad changes that are required to be made, the parties have a clear expectation of what the arbitral procedure will look like. And I think that makes all of the difference. They know that they can't ask for a 3-month extension for filing a submission, because then everything is going to get delayed. There'll be a watershed event. There'll be a cascading effect. They can't ask for a delay in the hearing because the award is to be issued potentially within 3 months of the hearing or what have you. So I mean, there are a number of tools, and I'm sure we'll talk about those in detail, and all of those have value and merit. But for me, the best or the most efficient tool is to have a really detailed and clear procedural calendar set out as soon as possible once the arbitration commences.
James, do you agree, or do you see other tools that are key?
Yes, I agree. Although cynically, I've definitely seen people who bring applications to try and push off hearings, even though there's what we all thought was a robust procedural calendar in place. But it really depends on how robust the tribunal is at the end of the day to actually enforce it. And to decline unmeritorious applications for extensions and things like that, even though perhaps rather extreme reasons might have been invoked, and for them to have been granted. In terms of, I mean, I know that there's a few kind of tools that have been promoted by certain arbitrators, and indeed they bear the names of those arbitrators. So I don't have any personal experience of the Kaplan opening, which is some kind of a preliminary hearing after the first round of submissions. One quite interesting innovation that I was reading about is Klaus Sachs protocol, which, as I understand it, is a procedure whereby expert witnesses are chosen. Effectively, the parties put together between them sort of come up with a bunch of names, and then there's a bit like appointing a president of a tribunal. You sort of whittle down the names until you have a panel of experts that become the tribunal's experts. That struck me. I mean, it's definitely a tool for ensuring efficiency, because I think it reduces the enormous volume of expert witness testimony when you have a situation where experts are just behaving like hired guns and endlessly writing enormous reports to try and beat every point raised by the other side. I think the tribunal can get to the heart of the matter much more quickly using some kind of a system like that. I also think from a fairness perspective, it seems to have, and I have no personal experience of it, but it does seem to have the benefit of reducing, or indeed perhaps eliminating altogether, the otherwise omnipresent risk of expert witnesses who are very much fighting from the corner of the party who has instructed them.
And Wendy, in your practice, have you seen these tools deployed? And we also about
sorry, go ahead.
No, sorry, I say that there's the Kaplan opening, the Sachs protocol. We talk also about the read retreat. Is this something that you come across often?
Not at all. I've only seen one of them being used, and that's because one of the members of the tribunal is named after one of those tools. But I think informally the tribunals do use it. I mean, if you think about it, I know many tribunals do get together before the hearing. I mean, if the hearing's been set for a week, they might get together the weekend before and start discussing the case amongst themselves. It may not be formally called, a read retreat, but that's what a number of them would do. And I think, and sometimes tribunals do ask questions about the case, and they do say, well, have you really dealt with this issue? What about this at CMCs, or maybe even during opening submissions? I mean, that's not the most efficient, but at least you get to hear the tribunal's indication. So yeah, that's the short answer.
And Raul, did you see that in practice? And if not, what do you think really prevents, a tribunal from, actually relying on those tools? Is it because, they have their standard PO1 and they stick to that, or is it the parties council who should, insist on relying on those tools?
Well, to be honest, I haven't seen any of these tools being used. The only tool, the new tool that I've seen, but it's not so new now, is the Stern schedule. I don't know if you'll have heard of this, but it's the Redfern schedule, which is in these annoying vertical columns. And Bridget Stern has turned that around and made it into horizontal columns. And that does improve the readability quite considerably, I would say. So I'm a fan of the Stern schedule. But besides that, the read retreat, the Kaplan opening, etc., I haven't seen those particularly being used in the arbitrations that I've worked in. I must say that in my view, what happens is that it's easy to get comfortable in arbitration. So one of the reasons why we're not seeing a lot of these novel tools being used is that, you know, you've done something in the past, you know that it works, and then you just repeat the same thing. And I think it happens with all of us, even when we are preparing our own pleadings and everything. If you had an experience with something successfully, you'll try to replicate that draft. And I think that's the problem, and that's why a lot of these mechanisms are not used. I think there's a bit of the burden or the blame to be borne by both the arbitral tribunal as well as the council. It's rare if council agree on, you know, insisting that an arbitral award should be issued within 3 months, that the arbitral tribunal will say, no, absolutely not, we cannot do it. You know, I think the council can be a little more proactive and a little more insistent in their approaches. And it's true that it's also for arbitral tribunals to kind of, you know, take up the mandate, read the submissions as they come in, proactively ask questions, for instance, earlier on in the arbitration, and, you know, insist that and play a more proactive role in directing the arbitration. So I think it does call for more attention, and the problem is that people are just, in my view, a little too comfortable in the way that they've done things, and they continue to do things in the same way. So you need to have some innovations in that to change that thinking first.
Now, one reason commonly advanced for parties or tribunals not adopting novel efficiency measure is the fear that awards will be, you know, challenged on due process ground. Do you think that this concern is justified? What is the attitude, you know, of, for instance, the court in the UK towards such challenges, James?
So as I think I briefly mentioned when in the first half of the session, under the Arbitration Act, the tribunal, and this is obviously can be tempered by whatever rules are agreed, but under the Arbitration Act, the tribunal has very wide discretion to set the procedure, provided it complies with its general duty to be impartial. So that's for reference, sections 33 and sections 34 of the Arbitration Act. And also, by contrast, the bar is very, very high indeed for having an arbitral award set aside before the English courts for a serious irregularity under Section 68. So all that's to say, these are quite clever initiatives, some of these things, and they're quite novel, provided that the tribunal expresses, well, assuming the parties don't agree and the tribunal just orders these things to be used, provided the tribunal expresses itself in clear and reasoned terms and, you know, otherwise complies with its duties, I don't think the use of these mechanisms per se will conduce to a greater likelihood of a successful challenge, unless, of course, by using them, one party is shut out or limited in its right to present its case.
And Wendy, do you think like the Singapore courts, you know, send the right signals to the parties and tribunals saying like, be comfortable, use efficient measures wherever you can?
Yes, so the Singapore approach is very similar to the UK. The courts have come up to say tribunals are the master of their own procedure, of course, always subject to a contrary agreement from the parties. So just to give the different perspective, in the event, and I know I'm jumping ahead a bit, in the event parties do agree on certain types of procedures and tools, I think then it's important that they be complied with, because otherwise the tribunal may open itself up to a challenge subsequently when it issues its award, because one of the grounds in the model law for refusal of enforcement or challenge of an award is when the arbitral procedure was not carried out in accordance with the parties' agreement. And we've seen that number of times in Singapore where people, the losing party relies on the fact that a procedure agreed procedure was not complied with to try to set aside the award. Of course, the fact that the agreed procedure itself was not complied with is not enough. You also have to show prejudice, but you know, you're opening yourself up to potential challenges if that agreed procedure hasn't been complied with.
So maybe Raul, one last question. So in Switzerland, if the tools, you know, agreed in PO1, for instance, or in the course of arbitration are not complied with, what are the consequences on the award?
Yeah, I'm not sure I heard the question correctly, sorry.
No, I was asking if, parties and tribunals decide on certain procedural, tools for efficiency, and one party does not comply, what are the consequences potentially on the award? Is that a risk for, setting aside of the award?
Well, of course, I don't think that is a real risk in Switzerland. I think really the court will look at whether there has been a serious due process violation or not. And if there has not been, then the chances of your arbitral award being set aside in Switzerland are extremely rare. So I think the courts have given the signals that they can give to arbitral tribunals and to parties to be as proactive as they can in terms of organizing and structuring their arbitral procedures. It's more for the parties and the arbitral tribunals to take that forward. Due process challenges, unless they are really egregious, I really do not see them succeeding in Switzerland, and historically they have not succeeded.
Thank you. I'm afraid we're already coming to the end of the first part of the webinar, and but I suggest we continue the discussion maybe in the networking sessions. So please do not say goodbye yet. Stay connected. It's as Katri said earlier, it's a great opportunity to talk to people from other region, which is rare these days. So now we're going to go back to the main room, and you'll be automatically assigned to breakout rooms for 3 rounds of 10 minutes. With the room will be composed of 6 participants to allow good conversations. And between each round, you'll go back to the main room and be reassigned to another room. So I hope you stay on for what comes next. And a big thanks to all our speakers. This was a very interesting discussion, which would obviously deserve more time. But thank you very much for participating.
To an end of our breakout session. So I think on behalf of ASA Below 40, I can say thank you all for attending. Thank you to all the speakers. It was a great event, and even if quite challenging with the time frame we gave to us, but it was a real pleasure, and I hope we meet each other in person anytime soon. And yeah, this is all I can say from my side.
Nothing else to add, but to say a huge thank you to SISC for the support in organizing the event and putting everything in place. Thanks a lot. And I was very glad to do this jointly with ASA Below 40. Great experience. So thank you all. Stay safe.